Walmart has done a good thing.
But are there times when the injured person can come out ahead and paying back the insurance is the right thing to do?
Well, I don't know if the right thing to do is what I would say, but there are certainly many situations where paying back the health insurer is not painful and is something that can be accommodated without a lot of stress on the insured. A lot of times the insured has to secure the services of an attorney to make that recovery, and so there's an attorney fee that has to be paid. And even with that occurring, there's still times when the insured can keep a little money and the insurance company gets paid back, the health plan gets paid back, and there's enough money to go around. But these plans have become rather brutal in that they require what's called first dollar priority. Any and all money you get has to be applied to this first without regard to how it leaves you, just as it did in the Shank case.
And so how much money are we really talking about in this whole reimbursement?
Well, I'm using industry statistics, and these are statistics given to the U.S. Supreme Court in briefing. And once again, we're talking about subrogation that was never allowed at law on personal injury claims, but now permitted under ERISA. They collect over $1 billion a year across this country, and that money goes to these insurance companies providing insurance on the risk, goes to the attorneys that are making these collections. It's an unbelievable industry that's developed just to try to pursue these and take the money away from people like Deborah Shank, who are living in a nursing home catastrophically injured.
And when it comes to health care reform, what needs to happen?
My understanding, and I think you know far more about what's going on today than I do, but there isn't a provision that addresses this in the current package. However, there is an amendment waiting in the House of Representatives being offered by Representative Braley of Iowa and co-sponsored by Representative Barrow of Georgia, and that would provide some common sense solution to this. It would provide that we make sure that the insured is fully compensated for injuries before we worry about giving back money to the insurance companies that are providing coverage.
Do insurance companies do good things for people? I mean, we seem to, in the whole healthcare reform debate, paint the insurance companies as the bad guys. And in some of these cases, they are the bad guys. But is there good there? Is there good intentions, well-meaning?
Well,
I mean, we rely on them so much.
You might be asking the wrong person. I know a little bit too much. The Aflac CEO, if you see the wonderful commercials on TV with the duck that goes and pays the pizza man the bill, for 2008, according to the reports released, the Aflac CEO received $76 million in annual compensation, executive compensation. The Allstate CEO received about $8 or $9 million. And I've taken a good look at the executive compensation that goes to these insurance companies, and it's just outrageous. America got a good shock last year as we started being tuned into executive compensation. Let me talk a minute about these reimbursement recoveries. When they come into the books of the insurance company, this is newfound money for the insurance company, and it has the ability to do with this money whatever it wants. Many in the insurance industry would lead you to believe that this is for the benefit of the other insureds or ratepayers, but that's not true. All of the published authorities tell us that these subrogated recoveries or reimbursement claims are just absolute windfall. And you see what happens actuarially when you write an insurance policy. You spread this risk out. And if somebody's catastrophically injured, if they're hit by lightning, all these medical bills have to be paid, and there's not going to be any reimbursement. If this person has a disease or illness, all these bills are going to be paid. There's not going to be any reimbursement. If this person's in a one-car accident where he or she is at fault, there's no claim. If this person's in a two-car accident or a three-car accident and they're at fault, there's no recovery. It's only when somebody has a catastrophic injury that there happens to be a fund of money that you pay back the insurance company. And so now if you're an insurance company executive and you're sitting in your home office and you've already actuarially spread the risk, and you look at this person who was in an accident a couple years ago and they collected $25,000, oh boy, if we get that $25,000, we can bring it in the company and we can do what we want with it.
Why is this your academic interest?
I don't know. I just it was kind of fate that brought me here. I got involved in the early 90s before this was an issue with ERISA plans in looking at subrogation on personal injury recoveries, because I was fascinated by the fact that it wasn't allowed at common law, and there were valid reasons. And at that time, some states were beginning to look at this and see whether or not they should permit it. So each state can make its own decision whether or not to allow it or allow it partially. But of course, the problem with ERISA and this health insurance for employers is there's no control over it. They just step in and demand top dollar, first dollar priority.
And what is the common sense solution for this?
Well, a number of courts and states take the position when asked, we allow reimbursement if the insured is made whole first, fully compensated. So if you're fully compensated, then yes, we don't let you collect any extra money. Another approach is to share the losses. If your true damages are $300,000 and you only collect $50,000, you've collected about 1/6 of your true damages. So we'll repay the insurance company 1/6. That's called pro rata loss sharing. That's another appropriate solution.
Okay. Do you favor one over the other?
Well,
or just something needs to be done?
I would tend to favor the full compensation remedy first. But the U.S. Supreme Court endorsed the pro rata loss sharing in 2006 in a Medicaid case. So in a Medicaid case where the government's paying the bills, a unanimous decision by the Supreme Court said that this person had medical bills paid by Medicaid of $215,000. And she collected $550,000. She too was brain damaged, and the fact is her total damages were $3 million, and the Supreme Court says, well, you're only collecting about 1/6 of your total damages, the $550. So Medicaid should only be paid back 1/6 of the $215, which is about $35,000. Medicaid had demanded to be paid back all the $215, which would leave her just the remainder between that and what she paid her attorney to get the $550. And so. I like that solution. I like the full compensation solution too. But anything's better than what is happening today in our federal courts, which is first dollar priority to health insurers.
And the health insurance or health care is such a personal issue. And people are angry and scared and confused over the whole health care reform process. After hearing some of these stories and what can happen if something bad happens to them, is it going to add more fear out there, more concern, more confusion?
Well, I think people walk around thinking they're invulnerable, and nobody thinks they're going to be catastrophically injured. And so this particular issue, it's hard for me to advocate for change because there's not an army of people that I can line up. These people are seriously injured and are ashamed. I mean, we have our case, not ashamed, but they're injured. They have, they don't want to go on the public with their injuries and talk about how they don't have, and they're living on welfare now. So I don't know that this is going to inject any more fear or panic into the debate that's already out there, but it's certainly something that could be logically and reasonably dealt with by Congress. And I would hope that Congress would take a look at it. And I've written and provided great information to each member of our congressional delegation on this issue.
And what is their response?
I haven't heard a thing, although I do want to say back in 2000, Senator Tom Daschle was very much interested in this, and he asked me to be part of the Patient's Bill of Rights, which was debated in the Senate, and I drafted legislation for that. And that Patient's Bill of Rights did pass the Senate in the summer of 2001, but that was right before 9/11, and after 9/11, this whole thing went away. Concern about individual rights and patients in the Senate Bill of Rights.
And so it's been a long process for you.
I've been involved in 3 cases that have gone to the U.S. Supreme Court. I've been in the U.S. Supreme Court and participating and helping the briefing and there for the oral argument, and been involved in 2 or 3 rounds in Congress drafting legislation.
And so